require them to take and pass the ACT test. You also now have to pass the core curriculum standards or you do not graduate high school. Okay, you can only accept 2% of your special needs students. So you have essentially your students that are entering the 6th grade next year. You've got 3 years, the 6th, 7th, and 8th grade, to design a program that is going to educate these students. What we anticipate is that there is going to be a wave of federal lawsuits that parents under the new guidelines can say, I don't feel that the education that's being provided to my student who is a special needs student is going to adequately prepare them to take an ACT test with no modifications. Thus, they cannot graduate your high schools. Thus, you can't meet FAPE. So what their remedy is they can sue you to provide them with private educational services, and there is no ifs, ands, or buts.
Does that money come out of roast and top?
No, that money comes out of your budget and your county commission. What will happen is there's already talk about these centers that are going to be constructed in the next 3 years that are like Sylvan Learning Centers that are going to provide private services in order to get the special needs student prepared to pass the core curriculums that go into effect in 2014 and to take the ACT exam. If what we are hearing is correct, they'll probably offer to the tune of about $5,000 to $7,500 a pop, just for that core curriculum. That money would then be passed on to the central office.
I have a question. Can the process be limited in its application if in fact the school system and Will County decline to accept any further raise to top funding?
No. Because even then, there are systems, oddly enough, that opted out. What we feel as a collective legal body is that since the state of Tennessee has adopted these core curriculums, you don't have the ability to opt out of those. So you're going to be held to the same core curriculum standard. And that is your best case scenario. Your worst case scenario is the student doesn't feel that even with supplemental services that they can obtain a FAPE and they enroll into a private school that is designed to provide the core curriculum training that they need. Campbell County would then have to pay to educate or pay the private school voucher for all of their Campbell County residents that go there. Yes?
Follow-up question, since you can't stop your inclusion even by those who didn't choose to participate in conception, and that's because of a state acceptance rule, can the county then in turn litigate the state to cause the state to have to bear the expense?
No, because this is a federal law through the Individuals with Disabilities Education Amendment 2004 that is put into place on all states. And the fact, what they're actually wanting to do is encourage the states that have not adopted core curriculum to do this. I went to a workshop with the Oak Ridge City School System to address this issue about 2 weeks ago to see what plans that some of the systems that are a little bit farther along in anticipating this need have, and the outlook was grim. One thought was to begin an inclusion-based curriculum on a regional level, and I've had some base conversations with Ms. Campbell about this as different ideas of how to address it have been coming up over the spring. Well, one idea are regional centers that would service multi-counties to where they started at the middle school level with a total inclusion-based curriculum. Oak Ridge doesn't have the number of students to do that, so that was not a reasonable alternative for them. The Anderson County system is going to try to begin, but we're doubtful that we'll get the funding from the county commission, a middle school that would be an inclusion-based regional center that would service Knox, Union, Campbell, Anderson, and Scott counties. That the option of funding is poor. If that occurs, you have the ability to send your high-functioning students to this academy to try to get them up, but then you have to have something in place when they return for the high school. And I don't have an answer for you right now as to what that is going to be, but 2014 will be here before you know it. And I think that you have to start with the idea that you've got to begin prepping these students in middle school. If you wait till 2014 and say, okay, now we're going to try to do something, roughly, let's say you just have 10% of the students that avail themselves at your 2 high schools, that cost is going to be in the millions. So right now, you're going to have to come up with a plan that is a plan that would be able to survive scrutiny by a federal judge that would come in, and because that's the question that's going to be asked. Under the Parham decision, which is the 2010 decision, the court would say, what plan do you have? Well, right now you have the benefit that there's no success ratio on your plan. You just have to have the plan. Then what will have to happen when that group cycles through, they will evaluate to see if your plan is meeting performance. But if you do not do this, you're going to have 10 to 15% of your students not be able to graduate. And if they are receiving special education services, then you're monetarily going to be on the hook for figuring out a way to assist them in getting the diploma. So that's a lot of information, but
I have one
that's
final
not
question.
Sir.
If in fact the regional service centers were done and or some kind of private learning facility, Sylvan or whatever, how would that help to abate the lawsuit? Couldn't the party still bring, the child's parents still bring the lawsuit to say, well, I don't care if it was them doing it or them doing it, I still don't think my child is going to.
Under faith, if there is a plan that's set, and keep in mind you have the individual education program to work with, the first thing that would occur is the parents would be invited to an M-team to assess an IEP, at which time Campbell County would make available to them an opportunity to go to an integrated learning academy. And if they choose to accept that, the parent, you can't force the child to go, the parent has to accept that. If they say, we're not going to accept that, then the court would determine, is their refusal of a service that you've offered reasonable? If the court says it's not reasonable, then the parents on their own forfeited the right. So the parent, to be able to get the private reimbursement, has to follow what you offer until such time that it's not proved reasonable. Why we're bringing this up to you now, 2 years or 3 years in advance, is that I don't want you to get to 2014 when those students start as freshmen at Campbell County High School and you don't have a program in place, because at that point the parent could sue you and say, show me the program. You go, well, we really don't have a program yet. And they go, fine, we're now going to Catholic High School or to CAK, and here's our bill. And I don't see any way that you don't pay that bill.
No, I'm listening today to some of the principals that were talking about this issue. We'll be meeting with the new commissioner just first of June. And now, one of the gentlemen asked the question about establishing some of the charter schools. But the issue there, if you establish a charter school, and you cannot identify one specific group for a charter school, so that becomes an impossibility.
Under the IDEA amendment of 2004, you would get sued to the Stone Age if you tried to establish a charter school for your special needs students. That's why these inclusion academies are such an attractive idea, because most rural systems don't have the numbers to justify doing it their way. And if you can get one system, if they could get one up that everybody could share from, you don't lose any but your, I suppose, your ADM money, because the federal money would go to that school. But when they come back to Campbell County High School or Jellicoe High School, you would get it back. And, you know, that would give you enough time to give, like Anderson County's proposal is to redefine their alternate school. What they're going to do is at the high school level, have a behavioral component with the alternate school, just like what is the traditional alternate school, but also have the pull-out component for test prep, for small class inclusion, for the special needs, that allows them to, like the Anderson County model is it to be an Anderson County High School to where a student, a special needs student could in theory go to the alternate school for their mathematics, go back to the regular high school for their related arts, and then go to the vocational school for their vocational programs, that would meet the federal model, but you have to have that school, because transportation costs would kill you if you didn't have it right there on the campus. Anderson County is big enough to do that, Clinton High School is not. So all of the Clinton students would have to go to the Anderson County High School to be able to participate in that program. You all, it's probably not a feasible way considering how far apart Jellicoe and Campbell County is. If Anderson County does come up with a regional academy, or you decide to do a regional academy for your middle school, that solves that small component, which you need to be worried on immediately, but you've got to come up with a plan for 2014. So I wanted to bring that to you because I know that Director Poston is going to start getting inundated with a lot of these questions because it's become the hot legal issue that the TSBA and the systems are now trying to address because truthfully nobody is prepared.
You see a growth in the transitional schools. When I say transitional, I'm not talking about just the alternative placement school. I'm talking about those students that are unable to meet the standard grade level and then just go through a standard transition.
What Maryville is going to try is going to be the 2-year transitional schools. The elementary schools, everybody feels that everybody in Tennessee is compliant because you have a special needs student that is basically with one teacher. So everybody thinks that all the elementary schools, K through 5, are going to be okay. Maryville is now going to set up 2 transitions before high school. They're going to go to a 10th, 11th, and 12th grade high school, and then you're going to have a 9th and an 8th grade and a 7th and a 6th grade. So the student will leave the middle school, they will then go to an intermediate school, which would be 6 and 7. Depending on how they're progressing, they can stay there or advance to an 8th and 9th. And again, they have the ability to stay back. They think that will help them, and it'll drop some of their smaller class sizes. But that's a huge construction cost to do that.
Don't you think also that, I know we will have to go through the standard in-service, staff development, those types of things, but it's just about as important having an administrative law judge there as part of the training.
Well, they're getting rid of that. That's the other thing. I used to be an administrative law judge for special ed, and now they're saying that they don't want ALJs to be there because they want to abolish the due process hearing. Under this 2010 decision, they think that needs to be taken away from the state level and you need to go directly to the federal courts. So the day of the due process hearing is essentially gone because they now have an individual right to action that they can sue you and they don't have to pay their attorney's fees. Their attorney's fees and costs are borne by the system to litigate. So I didn't mean to be so lengthy, but that was kind of a big deal that's come out and I wanted to get that information to you. So that's all I have, Mr. Chairman.
Dale,
Yes, sir.
you're preparing them to take the ACT. Does that mean we have to get them to a level where they can take an ACT and qualify to go on to college?
If they want.
I mean, it's not easy. It's easy to take a test, but it's what you score on it that counts.
And that's why the FAPE is so deadly, because FAPE says that requirement number 1 is that you have to prepare them to be able to continue their education. If a student would otherwise be able to continue their education to the collegiate level, then yes, it's your duty as a school system to prepare that student to take the ACT, sufficient of which they could get into a college. Obviously, a CDC student that would not have the ability to go would not have that requirement, but it's your severely learning, let's say it's your dyslexic or your learning disabled student that doesn't test well on a standardized test, but that otherwise with modifications would be able to compete in a college curriculum, then yes, you've got to prepare that student to be able to pass the ACT, because if they don't pass the ACT, they can't graduate.